Hello, Andrew Weaver at Lawyer Fair. One of the areas of law that we deal with most at Lawyer Fair is to do with commercial property, and in particular, commercial property leases. Commercial property leases. And it's a particular concern of mine that business owners get the best advice they can when they're entering these leases, because those tricky old landlords and agents are always going to try and load as much potential liability and risk in your direction as they can. So you need to negotiate from a position of some strength. So make sure you get some pre-lease advice. And in particular, this recording is looking at dilapidations and how to minimize the risk and potential liability if you do have a full repairing term within your lease. Ideally, you don't. The first thing to consider is you need to arrange a detailed schedule of condition. This will ensure that you're only obliged to bring the property back to the condition that it was when you took over. And if you've got a lease of 10 years, it's very difficult to remember specifically how it was. So make sure that you have a detailed schedule in place when you move in. Also, think about doing regular assessments of the condition of the property, in particular doing an assessment well in advance of leaving, perhaps 12 months. That will give you an idea, an indication of the work and cost required. And also related to that, make sure you're leaving before the end of the tenancy so that you have enough time to get those repairs done and finished. And finally, and this may be a little bit out of your control, negotiating in a weak market, the shrewd tenant can sometimes minimize, if not remove, a lot of these risks and liabilities. But clearly you're in a stronger position if it is a weaker market. So be aware of the market conditions in terms of your negotiation. But the bottom line is bring an expert on board and get them to help lead you through the lease negotiation process. Good luck. Andrew Weaver at Lawyer Fair.